Good morning, good afternoon, and good evening, everyone. My name is David Duvlamic. I am Associate Professor at the School of Law of Chongqing University in mainland China, and I am also the co-chair of the Asia Pacific Interest Group of the American Society of International Law. Today, we are here to discuss the cultural heritage and repatriation in the Asia Pacific region. Now, most Asian states have had some experience with the looting of cultural heritage, but in June 2024, China convened the International Conference on the Protection and Return of Cultural Objects, which resulted in the Qingdao Recommendations for the Protection and Return of Cultural Objects removed from colonial contexts or acquired by other unjustifiable or unethical means, referred to as the Qingdao Recommendations. Now, tonight, we are going to take a closer look at the Qingdao Recommendations and their place in the greater landscape of repatriation of looted cultural artifacts in the Asia Pacific and relevant international legal instruments. But before we do that, I'd like to introduce you to my co-host and co-moderator, Shay Esterling of the University of Canterbury in New Zealand, and co-chair of the Cultural Heritage and the Arts Interest Group of the American Society of International Law. Shay?
Got it. Thank you, David. We're really lucky to have with us here today our esteemed speakers to speak on this very important topic. Now, I do see our first speaker here to introduce, Zhu Yi. She is the Deputy Director of the National Cultural Heritage Administration of China Exchange and Cooperation Department. We're also very lucky to have with us Melina Antoniadis, an international lawyer and founder of Nostos Strategies, which is the world's first strategic consultancy on the return of cultural heritage. We're also very lucky to have with us Professor Gerstenblith, the Distinguished Research Professor of Law at DePaul University, and also the director of its Center for Art, Museum, and Cultural Heritage Law. And then finally, certainly last but definitely not least, we're very lucky to have with us Professor Lee, who is Professor of Law at Chung'an University School of Law in Seoul, Republic of Korea. Thank you all again very much for generously giving your time and agreeing to be here with us today to discuss such an important, interesting, and fairly recent development. A little bit of organization or housekeeping at the start, so to speak. The webinar will proceed as follows. David and I, as co-moderators, have prepared 4 questions, one for each of the panelists who have been allocated 10 minutes to answer. Following this, we will have a quick fire response from all of our panelists to a 5th and final question. Of course, throughout, all of our panelists are encouraged to discuss with one another and engage with one another. And then finally, at the end, David and I will open up to the audience questions, which they can ask via the chat box function that should be at the bottom of your screen here on Zoom to ask those questions that you may have for our panelists. So with that said, and hopefully housekeeping out of the way, we'll go ahead and we'll begin for the main event, as they say, who you're really here to hear, and that's our panelists. And I'd like to begin by asking our first question to Zhu Yi. And the question is what are the Qingdao Recommendations and what is their legal status? And also, if you could explore with us a little bit how they came about and some of the highlights of their content for us, please. Thank you.
Miss Zhu, you're muted. Could you please unmute yourself?
Okay.
Thank you.
So
we can hear you.
can you hear me?
Yes, I can hear you.
Yes,
Yeah,
we can hear
okay.
you.
So good evening from Beijing, everybody. Distinguished moderators, speakers, and colleagues focusing on the return and restitution of cultural property. Greetings to you all. Then I just, as the moderator introduced, that I work for the Department of Exchanges and Cooperation of INCHA. But my department also titled as the Office for Return and Restitution of Cultural Property Lost Abroad of INCHA. It's my pleasure to join the webinar today. I would like to take this opportunity to appreciate the American Society of International Law for its continued focus on the return of lost cultural property from Asia and its specific attention to the Qingdao Recommendations. Then my special thanks go to the Asia Pacific Interest Group and the Cultural Heritage and the Arts Interest Group of the American Society of International Law for organizing today's webinar and inviting me to deliver these presentations. So as the moderator asked, so I just would like to first to introduce the what is the Qingdao Recommendations. First, I would like to give you the background or the objectives of the Qingdao Recommendations. Then, as to the Qingdao Recommendations, the full title of this document is the Qingdao Recommendations for the Protection and Return of Cultural Objects removed from colonial contexts or acquired by other unjustifiable or unethical means. Very long name. But this name just suggests the Qingdao Recommendation focuses on cultural objects removed from colonial contexts, an issue that draws great attention by the international community, dedicated to the return and restitution of cultural property. By incorporating the phrase acquired by other unjustifiable or unethical means, drawing from relevant international instruments, national legislations, and policy documents. Then the Qingdao Recommendations expanded their scope of encompass a broader range of cultural objects directly or indirectly linked to the colonial context, as well as the countries and institutions that currently hold them. Then this positioning just aligns closely with the global trend toward museum decolonization and also the return of cultural objects removed from colonial contexts or acquired through other unjustifiable or unethical means. It also helps address the challenges of protecting and returning cultural property lost before 1970 Convention of UNESCO. Through this initiative, we just align with the global trend of dialogue and cooperation among civilizations, engaging with the international community in the shared pursuit of sustainable protection of cultural heritage and the harmonious coexistence and common prosperity of civilization. Then I believe this is precisely why today's webinar has chosen this topic and has attracted such active participation from scholars and professionals around the world. Then I would like just to introduce the Qingdao Recommendation, the objectives of the Qingdao Recommendation. I think I just have three objectives. First, to share and incorporate best practices from the international community. museums and also some relevant institutions with regard to the return and restitution of cultural property. By addressing the protection, management, research, and sustainable use of cultural objects removed from colonial contexts and also acquired through other unethical means. The document seeks to build a broader international consensus and establish a set of recommendations and guidelines with global significance. Second, as an important initiative in implementing the global civilization initiative and fostering a community with a shared future for mankind, the Qingdao Recommendations propose concrete methods and solutions for addressing cultural objects removed from colonial contexts and also from unethical means. The goal is to develop a fair, scientific, balanced, and sustainable framework for the protection and return of such cultural property. Then the third objective is to raise international awareness and stimulate discussions on the historical loss of cultural property from Asian countries due to colonialism, foreign occupation, and other activities. By doing so, the document just seeks to promote the return of lost cultural property from Asia and enhance its protection and sustainable use. And also, probably at last, I would just introduce the fundamental principles of the Qingdao Recommendations. Then first is to, the Qingdao Recommendation was just drafted based on the core principles and the spirit established by international instruments in the field of cultural heritage protection, including the 1970 Convention, the Convention on the Protection and Promotion of the Diversity of Cultural Expressions, and also the Mondial 2022 Declaration for Culture. And also the document acknowledges the efforts of relevant international institutions, such as ICP of UNESCO, in formulating recommendations for the timely return and restitution of cultural property lost as a result of a colonial or foreign occupation. It also incorporates the active practices of decolonization reflected in ICOM's efforts to revise its code of ethics for museums. Then these actions and initiatives serve as a guiding framework for nations, for museums, and also cultural institutions in the protection and return of cultural objects removed from colonial contexts. They further reinforce the international moral imperative in safeguard, protect, and facilitate the return of such cultural property. Then the second, the Qingdao Recommendations, after thorough research on national legislation, policy documents, and recent practices of relevant countries, draw upon and integrate these beneficial approaches. The documents just puts forward a solution that ensures compatibility while seeking a balance between countries of a region and current holders of cultural objects. It underscores the crucial role of dialogue and cooperation based on equality and reciprocity in addressing such issues, thereby fostering broader international consensus and solidarity. Then, third, the building on the respect for international conventions and ethical principles. The Qingdao Recommendations explore diversified channels for dispute resolutions and the protection and return of cultural objects. The document advocates for the establishment of international cooperation and of cooperation mechanisms among stakeholders across different levels and sectors, reinforcing the practical foundation for the protection and the return of cultural property. Now, because the time is quite limited just for my presentation, so I just give a very brief introduction then for the Qingdao recommendation. So later on, if you have more questions, and I would like to give my answer. Thanks.
Thank you very much, Ms. Ju, for your introduction to the fundamental principles and the objectives of the Qingdao Recommendation. Our next panelist is Melina Antoniadis, and we would like to know, from your perspective as an advisor to the drafting of the Qingdao Recommendations, first, who were the participants that participated in this process? What are some of the common issues or concerns that those states may have had? And how did the Qingdao Recommendations address those concerns for Asia-Pacific states?
Thank you very much, David. Hello, everyone from London. It is, of course, such a pleasure to be here, and I wanted to thank ASOL and particularly the Asia Pacific Interest Group for this very interesting event, bringing together experts and showcasing the Asian perspective, which I think is very crucial. So I was invited as one of the experts who helped draft the recommendations. And I'm also one of the advisors to Edenbridge Asia Law Firm, which is headed by Bradley Gordon, who has been appointed as the legal advisor for the Cambodian Ministry of Culture and Fine Arts. So I'm also going to provide that Cambodian perspective. Of course, I'm speaking in my capacity as the founder of Nosso Strategies and also as someone of Cambodian heritage. My mother's from Cambodia, so this ties quite nicely with this event. So Cambodia did participate in the Qingdao conference and also delivered a speech. The speech was delivered by Her Excellency Pen Moni Makra, the Secretary of State of the Ministry of Culture. Participants included countries such as Myanmar, Pakistan, Sri Lanka, Thailand, Vietnam, Uzbekistan, Kyrgyzstan, Turkmenistan, as well as Middle Eastern Asian countries such as Iran, Syria, Yemen, and the UAE. We had Armenia and Azerbaijan as well. The island nation of the Maldives was present. And we had countries like Cuba and Honduras as well. In terms of the common issues that were raised, I think the preamble of the Qingdao Recommendations is a good point of departure, which highlights the concerns that these states have with respect to this matter. One provision I wanted to draw everyone's attention to is the acknowledgement that cultural objects constitute a basic element of national heritage and identity, and an integral part of in the expression of cultural heritage and the enjoyment of cultural rights. So this, I found this human rights angle quite interesting because it draws attention to the importance of cultural heritage as a human rights issue. And we know that cultural rights encompass the right to access and to enjoy cultural heritage, and the right for individuals and communities to know and to understand and to benefit cultural heritage. For Cambodians, for example, repatriation of their antiquities is something more than just the return of an object. It's a return of our ancestors' spirits, the recovery of our national dignity following times of occupation and colonialism, and a reminder of what Cambodians have lost during those times. So the return of Cambodian sculptures has opened the doors to ancient civilization of Cambodia and has enabled Cambodia's next generation to learn and to understand their heritage and to enjoy their cultural rights, to reclaim part of their heritage and to enjoy it. And this is what is reflected in that part of the Qingdao Recommendations. A second item I wanted to draw everyone's attention to is the paragraph 5, which notes the difficulties with respect to current international instruments and domestic legislation, which come short of dealing with these issues. I'm not going to delve too deeply into this because I know Professor Gerstenblith will discuss this more in depth afterwards, but this has been addressed in the recommendations. There are 3 main international conventions: the 1954 Hague Convention, the 1970 UNESCO Convention, and the 1995 UNIDROIT Convention. And these conventions have been described in this field as quite vague and lacking precise conditions of implementation. They've been criticized for their inability to be retroactive vis-a-vis items that were lost prior to their entry into force. Now, in the case of Cambodia, these conventions do not, unfortunately, capture all of Cambodia's antiquities that were removed. This was highlighted in Cambodia's speech as well. Cambodia was under French protectorate for almost a century, from 1863 to 1953. And during that time, Western expeditions reached Angkor, and French colonial figures took an interest in Cambodian artifacts and brought them back to France to study. And these sculptures are today housed in the Guimet Museum of Asian Arts in Paris. So these conventions, unfortunately, do not apply to these items, which is one issue that was raised at the conference. And that concern is also related to domestic law issues, to private law issues such as bona fide acquisition, which is a legal hurdle in many domestic law cases, where if a purchaser purchases an item in good faith, they can acquire valid ownership of that item, even if the seller did not have the right to sell it. And also statute of limitations as well is another domestic issue. So this concern has been acknowledged in the Qingdao Recommendations. In terms of how the Qingdao Recommendations address common concerns, my first focus in this instance would be on 2 interrelated recommendations, which address ongoing hurdles faced by many countries, including Cambodia. And this is Recommendation 1 and Recommendation 5. Recommendation 1 recommends that heritage holders, such as museums and cultural institutions, are encouraged to prepare an inventory of collections that they suspect are derived from colonial contexts and to enable access to this information to countries of origin. And Recommendation 5 recommends that heritage holders should expeditiously carry out appropriate provenance research on their collections and should strengthen cooperation with countries of origin, including by allowing unlimited and unconditional access to provenance documentation and sharing these findings with countries of origin. Now, this is something that we really wanted to draft into these recommendations. It's the knowledge sharing, it's the research, it's the provenance documentation that should be shared with countries of origin. And this is relevant here because in Cambodia's case as well, in many restitution claims, museums and cultural institutions often place the burden on countries of origin to prove the provenance of items that they're requesting, to show that the artifacts that are requesting have been acquired by the museum illegally, rather than the museums themselves proving that they acquired them legally. So the burden is on the country of origin to have to prove that the museums acquired the objects illegally. And proving that museums like the Met or the British Museum have acquired items, under unethical circumstances is not an easy task. By nature, it's something that's very difficult, evidence-wise and logistically, especially given that the information is often held within these institutions themselves. Many times I've come across issues where countries of origin are required to show from which temples the sculptures have been removed. They have to show that the sculptures have been taken outside the country illegally, and have to show that the museums have acquired and countries like Cambodia are in the process of rebuilding after these tumultuous times. And in terms of resources and the capacity they have in place, this is something that's very, very difficult to do. This is also coupled with the fact that many countries of origin do not even know what's out there. They don't know what has been taken out of their country and what has been trafficked. They do not have compiled databases of their items held abroad. So it would not be easy for them to track back their antiquities. So in this context and with these difficulties in mind, it's important for museums to acquire and to compile this documentation on provenance and to share this information with countries of origin in order to unburden them with this difficult task. And the Qingdao Recommendations demonstrate an awareness that this is an ongoing issue with countries of origin, including the countries that have adopted these recommendations. In the case of Cambodia, to give a brief background, many museums currently still refuse to share provenance of their and their acquisition records with Cambodia, and it's very disappointing and helpful. But what is interesting about Cambodia's campaign is that we're currently working closely with former looters to track down the provenance of antiquities, meaning to link the antiquities that are currently in museums, in Western museums, with what the looters have taken from the temples decades ago. Many of these Cambodian looters were teenagers at the time. This was during the Khmer Rouge regime. So they feel bad now with what they've done, and they want to help and make up for the part that they played. So our team has gone to these looters with auction house catalogs, with museum catalogs, with photos. And from memory, these looters have taken the team around the temples and the ruins to show precisely where they've removed the sculptures from. And they do this by memory. They open the memory banks and they give information to the Cambodian restitution team. And this is something that's very special and quite unique, actually, that a team of current generation Cambodians are working with former looters. But of course, this doesn't take away from the fact that it's in terms of time and efforts and resources, it's not easy to trace and to track our artifacts. And so if museums would be able to provide this information first, at their own initiative, this would be something that is a true marker of collaboration. Just a final point I wanted to highlight as well is recommendation 6, which is states are encouraged to initiate discussion about returns of cultural objects removed from these contexts and to explore solutions in order to achieve genuine cooperation and to reach a consensus on returns. And in my opinion, this can serve to address issues of international domestic legislation, which comes short of dealing with this issue. So it's not simply about the legal perspective and litigation, but it's also about genuine cooperation between countries and reaching an agreement or a cultural partnership on these returns. So it's not only up to the countries of origin like Cambodia to commence discussions, it should also be on possessor countries. It's equally important for possessor countries to themselves, at their own initiative, offer to return items that they know have been acquired under dubious circumstances. I know that Cambodia has worked very closely with the US in terms of restoration of monuments, and they have plans with the Smithsonian Museum, for example, on an upcoming exhibition in Koh Ker. And so these types of collaborations remain very important, and once objects are returned as well. We know that private collectors have also, at their own initiative, reached out to Cambodia to return items in their collection. So again, it's not always about taking an antagonistic approach. I think if both sides can really sit at the table and talk about the way forward, I think this could be something that's very positive. And again, this is set out in the recommendations themselves. I'm conscious of time, so if you have any questions afterwards, we can discuss this further. Thank you.
Thank you very much, Melina. Really appreciate that. Our next question is for Professor Gerstenblith. I was hoping that you could speak to the Qingdao Recommendations from an international perspective and how they build upon or support the implementation of international cultural heritage law. And in particular, quite interested if you could speak to how you see this driving or moving forward restitution of colonial loot. Thank you.
Thank you. And I will start by sharing my screen. Is that showing correctly?
Yes.
Oh, okay. Let me get it in presentation mode. Okay, looking right? Thanks. So I'm going to pick up on some of the points that Melina made to give an overview of where current international law stands with respect to restitution, and then go to some of the obstacles, some of the recent changes in more in domestic law of some of the possessing nations, and make some of the points that Shay asked about as well, which is how can the Qingdao recommendations help? So just briefly, I'm hoping most of the people on the call are in fact themselves international lawyers. But of course, the main sources of international law are conventions and treaties, but these are legally binding only once a country ratifies it, and in some cases, domestic implementing legislation is required as well before the convention comes into effect with respect to a particular country. There's also several areas of soft law, resolutions, declarations, recommendations. Of course, Qingdao recommendations would fall into that category. And finally, customary international law, which is elements of international law that can become binding on a country even without ratifying a particular instrument. Now, the obstacles, some of which Melina mentioned, are but some additional ones that as international law developed over the course of the 19th century and included a recognition that cultural objects should be returned at the end of an armed conflict or at the end of an occupation, areas outside of Europe were not recognized as states and therefore did not benefit from these developing international law principles. So these principles primarily applied within Europe and then subsequently North America and a few other countries like the United States came into that. Second obstacle, which has been mentioned, is that treaties, laws, other legal provisions, for the most part, are not retroactive. And I will come back to that, ways around that. Third are the time bars that Melina mentioned, statutes of limitations, what in the US we call the equitable defense of laches, the more European civil law concept of prescription, which comes in various varieties. And also I like the fact that she mentioned the good faith purchaser doctrine of civil law countries by which somebody can acquire title even to stolen property. In the US, that's not the case. We follow what's called the Nemo dot rule, which is that if there's a theft in the chain of title, title cannot be acquired, but the claim of the original owner can be barred through one of these time-based obstacles. Some countries, particularly the UK and France, prohibit deaccessioning from what they call their cultural patrimony. In the case of France, that applies to all museums. In the UK, it applies to many of the large national museums like the British Museum, but not to all museums. Other countries do not have that prohibition in the same way. And finally, even voluntarily adopted ethical codes, particularly codes of acquisition for museum organizations, generally do not apply to acquisitions before 1970. That 1970 date, of course, being based on the UNESCO Convention, which I'll mention in a moment. Okay, let's see. Let's get this advancing. here we go. The basic principles of international law developed from the Lieber Code that was developed in 1863 in the United States domestically, and then the early Hague Conventions dealing with armed conflict, Hague Conventions of 1899 and 1907. Of particular interest to us, the second and third points, which is to prohibit pillage and seizure of movable cultural objects. And if such objects were taken during the conflict or during occupation, purportedly for the purpose of safeguarding them during the conflict, these should be restored at the end of the conflict or the occupation. But remember that these, at least at the time of the turn from the 19th to 20th century, applied primarily within European and North American countries. That doesn't seem to be working. The first of the three major conventions, as Shay mentioned, is the 1954 Hague Convention on the protection of cultural property in the event of armed conflict. Article 4 requires that militaries prohibit and prevent theft, pillage, misappropriation, and vandalism of cultural property. The first protocol of 1954 requires occupying powers to prevent the export of cultural objects from occupied territory. And also, not on the slide, if illegally exported cultural objects from occupied territory appear in the territory of another state party to the protocol, they are required to return those to the formerly occupied territory. The second protocol, adopted in 1999, expands on that by saying occupying powers must prohibit and prevent any removal of cultural property from occupied territory. Unfortunately, I'll mention the 1954 convention does not really provide means of enforcement. It's really left to the domestic law of each country to do that. The second protocol is more specific in requiring that, in setting out specific criminal provisions that countries that ratify the second protocol must follow. Outside of the context of armed conflict and occupation, we have the 1970 convention, which interestingly Melina referred to as rather vague, and it's really up to each country how it implements the convention into their domestic law. But at least in theory, the import, export, or transfer of cultural property done contrary to the provisions of the convention are illicit. And Article 9 calls on member states to assist each other in cases of pillage of only archaeological and ethnological objects, not the broader category of cultural property. The UNIDWA Convention of 1995 has somewhat similar provisions, but applied to private international law, and refers to actually the third provision that I have there, which is that objects that are excavated or that are obtained in violation of local law, in other words, the law of another country, when brought to another state party, to the UNIDWA Convention, are considered to be stolen property. And that's really a very important and very useful mechanism, because once something is categorized as stolen property, generalized law dealing with stolen property can also be effective, which is the third provision, the 2012 UNESCO UNIDWA model provisions on state ownership of undiscovered cultural objects. This is a model provision by which states can adapt their laws to provide that particularly unexcavated archaeological materials are owned by the state. And when they are removed, they are considered to be stolen property. Now, this principle has existed in the United States for several years, actually going back to the 1970s, with a recognition that Mexico's law with respect to archaeological objects made those objects owned by the state. And if they're removed without permission, they are considered to be stolen property. Now, this may not sound like it's useful, but I'm going to show in a moment how it might be. In the illustration in the middle is an Egyptian pharaonic sculptural head, which was involved in a prosecution of a dealer in New York the Schultz case, and it recognized that Egypt's 1983 ownership law was, in fact, established ownership. So when objects were taken from Egypt without permission, these were considered stolen property. This same law has been recognized by courts in Germany and now most recently in France, and in France also a criminal prosecution. But these laws go back to much an earlier time period. So on the left is a relatively recent case in New York involving what's called the Stargazer, this little statuette from the modern country of Turkey. And that case recognized the Ottoman decree of 1906 as establishing ownership. In fact, Turkey lost the case, but on the time bar, not on the question of ownership per se. It's a little bit more complicated than that. And on the right is a cuneiform tablet that was removed from Iraq illegally. And the case recognized the 1936 ownership law of Iraq. So this allows this concept of ownership, if the laws are in place in the country of origin, to recognize as establishing ownership and these objects, therefore, as stolen property. I'll mention quickly also there's a case from the UK involving Iran's ownership law from 1979, which again establishes basically the same principle. Now, this lovely map illustrates various bilateral agreements that the United States has with other countries under the 1970 Convention. As we've said, these are not retroactive in nature. And notice, really, at the moment, we have only two Eastern or Southeastern Asian countries, China and Cambodia, but several Central Asian countries do have these agreements. So the agreements themselves are not important for restitution of materials taken during the colonial period, but they do provide a framework of cooperation. The agreement that the United States has had with Cambodia is now, I think, about 20 years old. And it allows an opportunity for law enforcement in both countries to work together, to establish relationships, Ministry of Culture with the U.S. State Department, Cultural Heritage Center. And while, as I said, this is not directly applicable to colonial period materials, it nonetheless provides a framework of cooperation. Now, what has changed and what still needs to change, particularly in light of the Qingdao Recommendations? So first of all, in the United States, we have adopted what's called the Native American Graves Protection and Repatriation Act. It was adopted in 1990 to provide for repatriation of human remains and cultural items. A hook was found by which this applies to any museum acquisition regardless of when it occurred, as long as the museum or university is receiving federal funding. So it allows, in a sense, that relationship back in time. In 2016, the U.S. adopted the Holocaust Expropriated Art Recovery Act, which removed statutes of limitations that are state law in the U.S. So it shows that when the political will is there, these time bars can be removed. The problem is creating the political will. In the UK, first in 2004, the Human Tissue Act was adopted, which allows, it doesn't require, but allows deaccessioning of human remains from those UK national institutions that are less than 1,000 years old. And in 2009 was adopted a law that allows restitution of artworks looted during the Holocaust from the UK museums, and that was extended in 2019. I'll mention that the prohibition on deaccessioning, what's called the British Museum Act of 1963, some scholars believe that was specifically enacted to prevent restitution to the countries, particularly in Africa, as they were becoming independent states, to prevent the restitution from the national collections. France, which, as I mentioned, has an even broader law, but Emmanuel Macron commissioned a study, you may be familiar with, primarily of materials removed from Africa during the colonial period, and it was proposed to have three legislative changes. The first is to allow deaccessioning of human remains, and this was adopted, human remains that are date after 1500. And also the second legislative piece was to allow restitution of Holocaust art, things looted during the Holocaust. The third piece was supposed to be allowed to allow deaccessioning of cultural objects taken during colonialism. And I suppose it's not much of a surprise that that has not been adopted. Whether it will be remains uncertain. Well, I guess I'll leave it there. Remains uncertain. But I think we can see that these respond to some of the Qingdao recommendations. In particular, I'll mention paragraph 7, which talks about removing the time bars and also removing the prohibitions on alienability from the museum collections of the possessing countries. This is something that obviously needs more attention. The last, not the last slide, but the last thing I'll mention is the beneficial effect of publicity to these issues, because really, in my opinion, this is going to be a matter of public pressure, public opinion that's brought about through publicity. And this is where the recommendations, I think, can play a big role. There was a lot of attention brought to the issue of Cambodia, large part through efforts that Melina described. And in particular, the role of a dealer, Douglas Latchford, who lived in Thailand, but was apparently the main conduit for works that were looted during the Khmer period from Cambodia and then sold onto the international market. He was finally indicted on grounds of money laundering and other types of fraud, but he passed away before he was actually prosecuted. So we have the indictment, but that's really all. But it brought a lot of attention to holdings in U.S. museums that were related to him and that were clearly connected to the armed conflict, the terrible situations during the Khmer period, and other kinds of illegal activity. So on the bottom right here, you see two Cambodian sculptures. One was attempted to be sold by Sotheby's in returned eventually in 2014. Against the U.S. government filed a forfeiture complaint against it, but eventually it was returned without a full litigation. However, the basis that the U.S. government used was Cambodia's laws that go back to the 1920s. In relationship, the government alleged that this was a national ownership law. Not everybody agreed with that it fulfilled the requirements, but it shows that these older laws can in fact be used, or at least attempted to be used as a basis for restitution. And it resulted in the somewhat more voluntary return of the bima. These are both from Koh Ker, which Melina mentioned. And on the upper left is a more recently returned sculpture, one of, I think, 12, returned by the Metropolitan Museum in New York to Cambodia. And this was associated specifically with Douglas Latchford. And the publicity that has been brought is a really important key, that the public opinion is what will change in the cases where the legal situation is less clear. So thank you for that opportunity to speak. And I will stop sharing. Here we go.
Thank you very much, Professor Gerstenblith, on sharing the origins and evolutions of cultural heritage law and to illustrate how the Qingdao recommendations fit into this greater international legal context. Our next panelist is Professor Lee. And Professor Lee, we'd like to ask, from a Korean perspective, what are some of the important cultural heritage issues faced by the Republic of Korea, and how can we build upon some of the momentum from the Qingdao recommendations?
Okay. Just let me share the mic. Okay. Yes. Can you see my slides?
We cannot see your slides yet.
Okay.
We can see.
Can you see it?
No, we see a file with the slides inside, but unfortunately we do not yet see the PPT yet.
Okay. One more time. Sorry for that.
Yep.
one more time.
There
Can
we
you
go.
see?
We can see it
Okay,
now.
good.
Overseas
Oh,
cultural heritage status.
oh yes.
Thank you very much.
Great.
The floor is
Okay.
yours.
So I have two questions from the moderator. The why is that the cultural properties are located in Japan and the United States because there's the two what is a chaotic the situations in South Korea. One is the I think the colonial era, Japanese colonial era from the 1910 to here 1910 to 1945. Another thing is the Korean War between the 1950 to 1953. So between the Korea and Japan, the 1965 treaty was made in terms of the cultural return of the cultural property. So based on this treaty, some of the small portion of the Korean cultural property returned to the Korea. However, still many of the Korean cultural the heritage remain in the Japan. One the good example of the return of the Korean cultural object from the Japan is the annals of the Joseon dynasty. It is very precious and elegant the cultural heritage made during the Joseon dynasty. Uh, they were taken exported illegally by the Japanese government general of Korea uh, during the Japanese colonial era. And in the 1911, the University of Tokyo in Japan returned in this book to Korea. So, however, the many the looted by the Japanese government to Japan still do remain in the Japan. It's difficult to the Korean government to find them, also to ask them, and the what is it chase them. So it is really difficult because of the already this is discussion repetitive because the I think that treaty, including the UNESCO Convention and even the UNIDROIT Convention, did not have any retroactive effects. So basically, some of the stolen cultural property was returned to South Korea by using ironically, the foreign domestic criminal law or the private international law. One example is this one. Yes, here. And the royal seal of the Queen, the Munjang, was returned to South Korea based on the National Stolen Property Act. Uh, this also returned to the South Korea by using the National Stolen Property Law Act. So, okay. Yeah, this one is the return to the South Korea based on by using the private international law. In this case, the governing law is the Virginia law, not the Korean law. So it under the Korean law, basically I think that the purchase of uh, I think buyer of this cultural object will acquire in good faith. So his possess is illegal. However, under the Brazilian law, there is no good faith acquisition of the stolen property. So the Korean court applied in the Brazilian law rather than the Korean law. So this is the okay. I skipped this part. What is the issues of the Korean what is the lessons and the challenges that we are facing now? So except for the national and/or the royal seals, it is difficult to show that the overseas cultural properties were stolen. Except for the restitution of the overseas Korean cultural object from the United States, it is really a challenging task to avoid the good faith acquisition defense. Except for the restitution of the overseas Korean cultural object from the United States, the owner in Korea need to take into account the regulation related to export, the permit of the country where they're located. For example, in the France. So, as I mentioned, the Cultural Heritage Protection Act cannot be retroactively applied for the stolen cultural property during the Japanese colonial era and the Korean War. So also we are talking about we don't have acquisition. What is it? There's no exception to acquisition by prescription. The Scotland and the Switzerland. So nowadays the Korean government is talking about how to what is it, legislate the law the barring the acquisition by the prescription. Also, we are taking the legal challenge the related to Washington Treaty. So the Washington Treaty deal with the endangered species. So the some of the seals was made by the ivory, so that we cannot taking the what is it the import those good the cultural object from the United States because sometimes it is against the Washington Treaty. So another thing is we are nowadays that in Korea we are talking about the adoption accession to the Hague Convention of the 1954. Problem is at the South Korea is and the North Korea both of the right now is on ceasefire, so it's difficult to assess the Hague Convention of the 1954. However, the Korean government is very active to try to adopt the assessing the Hague Convention. I've been given the 10 minutes, so almost stop here. But I need to briefly touch on the Qingdao recommendations. So certainly, it includes it's notably include human remains. It's a good things. So another thing is I have some doubts as to whether it's a colonial context can include the Korean War period time. However, I think uh, so uh, uh, the wording culture object acquired by the other unjustifiable or the unethical means can include the Korean word. I think I might be wrong. Maybe some other panelists can answer for these questions. So I stop here. Thank you. Okay. So I'm done.
Okay, thank you very much, Professor Lee. Our final question goes to all panelists, and we are wondering, what does the future hold for the international cultural heritage law and the Qingdao recommendations in the Asia Pacific? So what do you see coming in the future for Asia Pacific cultural heritage, its restoration, and also the Qingdao recommendations? Perhaps we could go in the same order that we had proceeded in. Ms. Chu, if you have any further comments on this question. Well, if Ms. Ju is not there, believe we'll start with Melina. Melina, would you like to go ahead?
Yeah. Well, I'm very happy with this conference and the recommendations, because I would like to see a bit more of cooperation and collaboration between Asian countries. I know that the African Union, for example, the theme of this year is African reparations, and it includes return of cultural property and cultural artifacts. And I would like to see something of a more of a regional consensus within Asian countries in terms of the way forward. Also, information and knowledge sharing, capacity building amongst Asian countries as well. And just sharing strategies, how, for example, with Cambodia can help many other countries in terms of how to go about affecting returns. So I would like to see a lot of collaboration in that respect, but the tide is turning, and I've seen with my work as well that museums and cultural institutions are much more aware of this issue of returning items that have been acquired under these circumstances. There are codes of ethics. They're hiring provenance researchers to look into the items in their collection. So there is a positive movement. There's a lot more to do, but just to end on a positive note, I think we're seeing a change for sure. And also, Professor Lee's query in the end, the recommendations do say that items that are removed by unjustifiable or unethical means would fall under these recommendations. And so, to answer your question, yes,
Okay.
the Korean War
Right.
artifacts would fall under these recommendations. It was broadly drafted on purpose for this. Thank you.
Yeah, good to know.
Thank you, Melina. Maybe we can move on to Professor Gerstenblit. If you have any final comments on this question.
Sure, thank you. Well, I'll agree with everything Melina said, and I will say that Cambodia definitely has been a leader in this regard from the perspective of Asia. My comment is that it seems there's been a lot of attention paid to the colonial period, but it focuses primarily on Africa, and in particular, the objects taken from Benin have really captured, certainly in the US, and I think to a large extent in Europe as well, largely due to a book by Dan Hicks called The British Museum, which really focused on the relationship of the British and Benin and the objects that were taken. So I think in terms of Asia, it's primarily been this focus on Douglas Latchford and the returns that came about. So what I think is needed is not only this cooperation regionally within Asia, but it has to come to the attention more certainly in the US, and I would guess also in Europe, than it currently has been. The story has to be appealing, to the public. And that is actually how you get change, is in these areas that fall outside of the law. You can try to pressure changes in the law as well, as we saw in France. But there's not nearly as much general knowledge, I think, of the situation in Asia in comparison, let's say, to Africa, in terms of the colonial period or imperialism. And in some ways, the colonial definition is a little bit less clear. And I think that's part of Professor Lee's point as applied to Asia. But again, the recommendations go beyond that strict definition of colonialism. So I think the recommendations can play a role in bringing that public attention, which is just really crucial. So thank you.
And Professor Lee, you're next.
Yep. Okay. The Qingdao recommendations actually did not mention about the retroactive, the effects, but in reality, it create the retroactive effects. So maybe the clear the foundations for the Korean legislator to take into account, and so I think that this is a good the start for the Korean legal community to push up to the Korean legislator to adopt the exemption from the what it called the prescription the acquisition by the prescription. So it's a very good start from our perspective.
Just to make a follow-up comment, if that's okay, David. I completely agree with Professor Gerstenblith on this public awareness, which I think would be helpful as well for Professor Lee's the comment you just made about pushing the legislature. I think it is important for Asian countries to, I mean, make this cause much more public. And this is why these conferences like today are very important. But perhaps countries like South Korea can host events as well. China did this Qingdao conference, which I think put this issue on the map regionally, and I think countries can do a bit more. Maybe Cambodia can host an event, who knows? But I do think that in terms of public awareness, it's so important. Like I said, it's not just about litigation or fighting, it's about showing the public what's out there. And I think Asia has a lot more to do in this respect, yeah.
Ms. Ju, we'll give you the last word on this question. So what does the future hold for cultural heritage law and the Qingdao recommendations?
Yeah, thanks a lot then for the comments of my colleagues of this webinar very much, because for other experts, you are the experts in the field of law. So comparing with you, I am a practitioner. I have worked in the field of the return of restitution of cultural property for almost 30 years. And I just have dealt with many cases of the return and the restitution of the cultural property of Chinese cultural property lost abroad. Then just I witnessed the development of in the field of the return and restitution. So do remember that in the year of 2002, there is a declaration of 18 world famous museums. And then what did they say at that time? But now there is a new international trend. So as the practitioner, and I just noticed that there is good international trend. And I also noticed that there is very good practices. For example, as the good practice of my Korean colleagues, and also in Cambodia, and also in the United States, in Germany, so many good practices. So that is why we just want to, I just noticed this kind of practices. So that is why we just want to have this kind of Qingdao recommendation. Then, so, just now, Professor Petty just mentioned that Qingdao recommendation is just a kind of a soft law. I think that is true. And according to my experience for almost 30 years, the Qingdao recommendation is just a start. I just hope that Qingdao recommendation can serve as a starting point for the international community then to engage in deeper discussion on the protection and the return of cultural property lost historically. because comparing with, I mean, the return of culture and restitution for those cultural property, I mean, can covered by the 1970 convention. Then this return for cultural and the restitution of cultural property, which has lost 100 years ago. Just now, my I mean, Korean colleagues just share. We just share the almost similar history and a similar history of losing our culture objects. And I just hope that for this very difficult point for the return and restitution, then we can have a deeper discussion for these cultural objects. Then through more meaningful discussion and practical exploration, we can refine and enhance the implementation of these recommendations. And also, ultimately, we aspire for nations to reach a more legally binding international instrument. I think that is what my dream is. And also ensuring that more cultural objects lost historically rightfully return to their countries of origin, better not only return, but also better protected and started, not only after the return, but also even at, I mean, the country who collected those objects right now. I think you still remember that probably last year, world famous museum just lost over thousands of objects. Yeah, so I think all these objects should be protected and started even right now, and that diverse civilizations can continue to flourish their frightful cultural landscapes, and also even after the return of these objects, then these cultural objects can be a kind of a bridge to still combine the country of origin and the country who has ever collected these objects together. And that is also my dream. Thanks.
Thank you very much to all of our panelists there. We'd like to go ahead and open it up to our audience. We have a number of attendees that I can see here online, and we have about 15 minutes for questions. You can ask a question via the Q&A function that should be available to you at the bottom of your screen. I don't see any questions that have come up just yet on my end. So wait for some of those to filter through. But if I could perhaps abuse my privilege as one of the moderators, I have a whole host of questions. Really fantastic presentations, really a lot of food for thought. And just my brain is tipping over now with a lot of ideas and questions kind of fizzing away. I suppose a couple of questions and observations, and just to the panel in general of whoever kind of wants to jump in. One thing that really struck me is a number of things. A common theme amongst many of the panelists is this idea of knowledge sharing, information sharing, this idea of the need for inventories, NAGPRA, for instance, as a model there of inventories that were needed to be done immediately after its passage in 1990. Which brings me to really think about local communities within states. Do the Qingdao recommendations say anything about local communities? Of course, it talks about repatriation to the nation state, to the country. Is any provision in there made in relation to local communities, minorities, indigenous peoples? And also, I'm wondering, were minority groups and indigenous peoples participating in the drafting of these recommendations? Because I imagine there could be a lot of knowledge sharing and cooperation there in terms of advocacy, inventories, a whole variety of things. Sorry, that's quite a lot. So I'll stop there and as I say, abuse my privilege and throw that open to anyone on the panel as we wait for some more questions to filter through. Thank you.
Thank you for your question, Shay. In terms of who participated, I'm not aware of any communities participating at the conference. I know the International Council of Museum and a few of these sort of institutions did participate. But just in terms of the role of communities and peoples in these recommendations, of course, the human rights perspective and the cultural rights angle that one of these provisions highlight is, I think that's directly applicable to peoples. I think number 3, so the third preamble says recognizing the desire of countries of origin and their peoples for the protection and return of cultural objects. I think that falls squarely under peoples, and also the provision that I mentioned before on the cultural rights. So I think it was drafted with that in mind. It might not be as explicit, but it does. I would argue that it does encompass communities and peoples. Yes.
Yeah, thank you very much. Oh, sorry, David, were you gonna
That's
hop
okay.
in there?
If there's nothing else to on that specific question, I think we can move on to the next question. Or
So I was gonna, move on to the next one. All right, David, I'll let
okay.
you take the next
We have
one.
a question in the chat box from Jakub Niszewski. I have a question about the social awareness and the pressure that was mentioned by the panelists. So I believe Professor Gerstenblith was talking about how we need to increase the publicity of these issues, especially in Asia Pacific, and that a lot of the focus is right now is on Africa. And the question is, how can international law, international cultural heritage law, foster this public interest in heritage restitution?
So I can make not the answer. It's a comment on his questions. It's the Korea did not signed up for the 1995 the UNIDROIT Convention, even though we are the signatory to the 1970 UNESCO Convention. So the reason why we didn't the sign up for the 1995 the UNIDROIT conventions, even though it is a self, the executive the instrument, but it does not have any the retroactive effects. So basically, it does not solve any issues arising out of the colonial era or the Korean War. So that's why what happened. So basically, the recently the Korea, I think they returned the ownership of the dinosaur fossil to Mongolia. However, it was loaned by the Korean government to the Korea. So it was smuggled from the Mongolia to Korea, but it remained the object is the cultural object remained Korea. However, we returned the ownership to the Mongolia. So I want to just emphasize, the cooperation and between the state of origin and the state of possessor. So this is the another development for the international instrument, I think.
Thank you very much for that. We have another question that's come into the chat box. Did the fact that some of the artifacts in Cambodia were given by those in power between 1961 and 1970 act as a preventative factor in the return of these artifacts? And that's specifically directed for Melina.
Well, I haven't come across this sort of issue in any of the discussions I have had because obviously the current Cambodian government is not addressing any allegation that they were involved or that the Cambodian government at the time was involved in I guess removing artifacts from the country. I think the focus is the ethical angle and whether it's ethical for museums today to hold items that were acquired under those circumstances. So whether Cambodians were involved or not, whether the looters, were Cambodians or not, whether they gave them permits, all those questions that happened historically are not always as relevant today. What's relevant today is whether museums and institutions can hold items that were acquired under these unethical or dubious circumstances. So what those circumstances are is quite broad. And I think this is the part of the problem is that countries like Cambodia have to show that they were acquired illegally, but museums know that they were acquired legally. They acquired them without any proper licenses. They acquired them knowing that they were smuggled out of the country. They acquired them sometimes in cahoots. So curators in cahoots with Douglas Thatcher, for example, with dealers, knowing that the items were taken away, they still acquired them. So I think that part of the history is important, and whether they're currently held now is the question. Is now okay? Is it okay for museums now to hold those items and to keep them, knowing that they were acquired under those circumstances? I think that's the more relevant question.
Patty, did you want to raise your, please
Yeah.
proceed. Go ahead.
Going back to the comment before about what international law can do and Professor Lee's comment. So neither the 1970 convention nor the 1995 convention are retroactive. And the 1970 convention arguably is quite weak because it leaves it to each ratifying country how to implement it. And I'll say the way the United States implements it is particularly weak, although some other of the collecting market countries are arguably even weaker than the United States is, which is kind of remarkable. There have been attempts very recently, particularly with respect to the 1970 convention, to broaden its focus, both in terms of recognizing the issue that was raised before about communities being able to recover as opposed to the country recovering. And the guidelines that were proposed for the 1970 convention recognize that human remains are not covered by the convention, and therefore when they are returned, they can be returned directly to the relevant community, descending community in most cases. Whereas when something is done directly under the convention, it needs to go to the country itself. So these attempts to write guidelines that broaden, for example, the 1970 convention, have met a lot of resistance, not surprisingly, from the countries that have already ratified these instruments. So you can't go back and change the instrument. And in my opinion, not that I personally like this, but the possessing countries are not going to ratify a convention that is retroactive in nature. And we just have to kind of acknowledge that and deal within it. And I think, for example, the publicity is a big way of doing that. And it's almost a naming and shaming kind of activity to bring museums into understanding that they have a role to play beyond what the law itself provides. And I guess my last comment there is also to emphasize what has been said, which is that these restitutions and repatriations can provide means of very cooperative arrangements that can be a win-win. Objects that have been seized in the United States, for example, from Yemen, from Libya, from other areas, have a time while ownership is returned to the country of origin, the correct owner, the objects are then loaned back in ways that can be cooperative and essentially be a win-win for both the country of origin and where the objects are currently located. And I would encourage looking at these for more creative solutions rather than only, you win, I lose, or the other way around, trying to make it a win-win situation, as has happened in some cases with Cambodia. My only concern is we thought we were there in 2014 when, because the Metropolitan Museum and some other museums returned additional pieces, I think to Koh Ker. And yet it seems like the promise of those cooperative agreements weren't really fulfilled as they should have been, as we had hoped at the time. Thank you.
If I may just make a comment following what Patty, you said about cultural partnerships and practice. I think that in terms of international law, so these types of recommendations and declarations can serve as evidence of opinio juris, which would be evidence of customary international law. And these types of cultural partnerships and collaborations can serve as state practice, which is another component of customary international law. So I think if states keep doing what they're doing in this regard, making these declarations, coming up with these recommendations and this soft law instruments, which is soft law, it can still inform customary international law, which is binding. And so maybe an advisory opinion in this regard from the International Court of Justice on what the law is, whether states are bound by whether it is customary international law to return items that have been stolen, could be something to look forward to in the future. So I think states should just keep doing what they're doing and keep showing that they're collaborating and that this is an issue. And maybe in the future, we'll see this turning into binding law.
Fantastic. We're almost out of time. I just want to take the opportunity to thank all of our panelists for generously giving their time to be here with us today. Really, really appreciate it. I think, as you've all said, this is an issue that we need to keep talking about. We need to keep discussing. We need to keep pushing. I think it's really drawn together a lot of really interesting threads, from ethics to political will to soft law, hard law, all sorts of threads coming together here. And yeah, we really appreciate you guys taking the time to discuss with us today. And I'm very conscious of the time, and that Asil is going to tell me now in 30 seconds that we're done. So thank you all very much. We really appreciate it. Thank you.